Hello, I'm Laura Furiosi, divorced mother of 3, and I'm here with my mother, Lynette Galvin, with 35 years' experience in family law. You're listening to the Divorce Course podcast. Through our candid discussions, we hope to help you through your divorce or de facto separation. We will be answering the most commonly asked questions and covering the stages and steps that you will face on your way to freedom. Are you being stonewalled, or are you trying to divorce someone who won't even speak to you or return any of your letters? Well, this episode is for you. This episode is called How to Do a Divorce and Settle When You're Being Stonewalled or Trying to Divorce Someone Who Doesn't Want to. Hello, Mum. Welcome.
Hello, Laura.
And sorry about that, like you said, not a very snappy title.
Not very snappy title.
But we've come up with 7 tips because we've had people been writing in and they're in the avoidant category. And it's not high conflict, it's not manipulative, controlling, which sometimes it can be though. But these people just don't return emails, they don't return letters, they don't want to sign any documents, and these poor people are banging their head against a wall.
Yep.
And so, Mum, you told me we've come up with 7 tips that you've told me about, and there's one magic one, number 7, which we will tell you at the end, which basically will make you feel a million times better if you are struggling right now with an avoidant, stonewalling kind of person.
Because just remember, the Family Law Act has been in place since 1976. So that's, gosh, how many years? 40-something years. And anything that someone could try to do has already been done. And the Family Law Act has been tweaked to make sure that that can be dealt with. And also there are precedents that show how to deal with these sort of people. And over my 35 years, I've got this toolbox of how to deal with people like this. And I think sometimes it's worse to have an avoidant person on the other side than it is to have someone who bombards you with letters, because at least you feel like you could be getting somewhere if you're in a dialogue. But if you're talking to a wall, you might think you can never get out, but you can.
Well, that's good news because I guess a lot of people, they talk about narcissists and the high conflict and manipulative ones, and there are a lot of people out there, maybe the avoidant person is just depressed, in denial.
Or being awful.
Or just being horrid. And I guess you could be a narcissist and just ignore all the legal letters.
Yeah. Oh, yes.
Yeah.
If you really want to upset someone and it's their way of disappointing you at every turn and showing complete disregard for authority, and that is they just don't answer. So, yes, so we can deal with them. There's a lot that says you see a lot in the movies and in books about, he won't give me a divorce, she won't give me a divorce. Well, in Australia, you don't get given one. Yeah. You can just go get it.
Yeah. And I guess in property settlement and children's matters, I have heard from some people who've written in where their ex is happy to complain and argue about all these other things, but when they're trying to narrow the issues or trying to get them to nail down, they just don't say boo. It's like this weird Jekyll and Hyde situation where they only want to engage if it suits their purposes.
Perfect. Yep, perfect. Yeah. Absolutely.
Okay, well, let's get into it then. So if you are listening and you are having trouble getting someone to respond, sign something, negotiate, mediate, you name it, Mum, we're going to talk through it.
Yep.
And the number one thing
is don't do a joint divorce.
Just the divorce itself.
Yep. Yeah. The actual ending your marriage so you can marry someone else. You don't have to do that together. Yes. You can do that on your own, and you can be the person who applies and who gets the divorce against the other person.
So just to be clear to those who don't know about the divorce process yet, if they are not looked at it yet, there are 3 ways to do a divorce, or 2? Two ways. Okay. So the first way is you do it together.
Yeah. So the way that used to be the most common was the sole application. Now the most common one is the joint application. I think it's a little bit cheaper to do together, and some people think it's a nicer thing that both of you apply. But if you've got someone on the other side who's not going to play ball, don't waste your time and money applying for a joint divorce
and then not getting them to sign.
And they won't follow through. So yes, do your own application.
All right, so when you go and download the divorce papers, go and choose the sole application instead of the joint, and then you fill it out and follow the steps. If you're interested, we have the divorce course where it's a whole module on it. We talk you through it and how to do it, because it is a little bit tricky. There's a lot of serving people and proving that you serve people, and gosh darn it. But anyway, in the end, you can do it.
Yep.
Do it yourself. And why is that, Mum? Why don't do a joint divorce?
Because at any stage, either from signing the papers and acknowledging things, they could stuff it up by just not signing a document that you need. And so you've left your power in their hands. If you know someone's avoidant, don't take a chance. File the divorce, hurt feelings notwithstanding, you've got control. So if your ex stands there, I always say this to my clients, if he or she stands there with their arms folded, their eyes squeezed shut and their back to you, you can still serve them, you can still get your divorce. It absolutely, the getting the divorce by yourself requires zero cooperation from the other person. And sometimes getting a divorce might be the trigger that will help that avoidant person face up to things. But remember, you've only got 12 months after your divorce is final to file for property settlement. So there's a time limit there. This is general advice only, but just remember this, guys.
So if you've got an avoidant person who's going to be a pain to get them to agree or sign anything for your property,
maybe do the divorce later.
It might be a good idea to start the divorce after you've started the property.
Yeah, that's right. Yes, that's a good tactic. It depends on the person you're dealing with, but you have to be separated 12 months before you can apply for a divorce. But some people don't apply for years and years. It might be against their religion. They haven't found anyone they want to go get married to, or So, and it's not until the divorce that the time starts.
Okay.
So be careful if you do the divorce with an avoidant person. In a way, you're starting your own clock, and then with them being avoidant, you'll have to be proactive in your separation and property as well, and that is probably have to apply for orders. You only have to apply within the time frame. You don't have to have your orders settled.
All right, well, that gets us to number 2. So you've done your divorce, or you're going to wait a little bit, and you've got to start that negotiating.
Yeah.
Who gets what? How much money have you got? Who's, what do you want? So in the negotiations, for someone who's stonewalling or just avoidant, so you might, write them an email, or you might say it to their face and they'll say, I'll get back to you, I'll get back to you, I'll get back to you. Or they might just not write anything. What do the people who are banging their heads against walls trying to get some sort of negotiations happening?
The first tip is, of course, you have to try to negotiate, but don't wait an inordinate amount of time. Don't give them 2 full weeks. Give them 10 days and give a time on that 10 days. And if you haven't got an answer in your email to them, you can say kind of a self-enacting provision there. So say, for instance, early on, you might need to get the house valued, okay? So, dear such and such, your ex, I think we need to get the house valued to see if we've got to sell it, how much we can get for it. Instead of saying, what do you think, say, I propose these 3 as valuers, and if I don't hear back from you, I'm going to choose number 2. And that way you've set in a process that even by not answering, they've actually answered. Yes, that's right.
So you can't get in trouble for that?
No.
They can't say, but I didn't agree to that value.
Say, why didn't you respond to the letter? It was a fair enough letter.
Okay.
And you gave them 10 days, and they had a clear deadline.
So can you do that for everything?
Pretty well.
Okay.
Pretty well. You can. So when you've got someone really stubborn on the other side, that's how you move matters along.
Okay. And what sometimes you might have, say they are avoidant, but they are maybe controlling.
Yes.
And they don't engage on things that you're interested in solving. That will probably drive them bonkers because they don't want you to have a choice. So maybe that would be a really good strategy.
That's right.
I guess you've got to think about how your ex works and why they're motivated to be avoiding, and try and be aware of that when you write a letter.
Yeah, and don't let their agenda and their priorities railroad you from your agenda and your priorities. So you just keep marching on towards the end of the case.
Okay, so number 3 then, because we were talking about valuing the house, when you're going through property and you're trying to figure out who owns what
there is to divide.
What's the strategy there for people who are being stonewalled?
Okay, so particularly if you're already in court and if you've got an avoidant person and you're struggling, you may have to at least start the proceedings to get their attention.
Yeah.
Then you've got the power of subpoenas, and that will get you the information. So I say, don't ask.
Yeah.
Find out.
Yeah.
So get someone to do the searches on SciTech, and there's a whole thing on that in the course about how you can find out what houses they own, how much they paid for it, sometimes what the mortgage is,
how much their car's worth,
whether they've got a debt on their car,
how much their business is.
Yep. Who are the other shareholders, if they've got other businesses, and we've found that out recently in a couple of cases where there was a whole other company that my client hadn't been aware of.
Oh, wow.
And that's not a rare case. That happens a lot.
Yeah.
So you find out and establish the facts. Now, what I do when I know all those things is I don't always tell the other party, so the avoidant person, how much I know. I just go something like, we've discovered these companies, or we've discovered this, or there's a debt on the car. What is it, or what sort of car is it? And I wait to see if they're going to be honest. So if they write back and go, oh, yes, there was a Mercedes hatchback we bought back in 2012, and my searches have shown that, I go, all right, he's probably going to tell the truth on that.
Yeah.
So, yes, you ask, you find out. If you're still a director of a company, you're entitled to have a look at the books. You can subpoena the accountant. You can subpoena their lawyers.
So if you've got an avoidant person, one way you can do is subpoena.
If you'll have to go to court and then do the subpoenas to find out.
And we talk about subpoenaing, and I think there's an episode on it in here as well. So that's one way if they've got their eyes shut.
Yes,
that they have to. What about, so with disclosure and things like that, because people banging their heads against walls with avoidant. So what about like bank balances and that's tip number 4. Guess sometimes.
So subpoenas and things are things that are really good to use against people who've got their eyes shut tight, okay? But if you're actually, and of course I hate calling it disclosure, the old word was discovery. And so disclosure implies they're going to let you know what they want you to know. Discovery means you go, hang on a minute, let's look in that bag. What else you got in there? And so I call it discovery.
Okay.
And I think if there's stuff that you can't find out, for instance, if you haven't started in court yet, and so you can't issue a subpoena and they're being very close-handed, just give a figure that you think it's worth.
Okay.
Maybe a little bit higher.
Yeah.
And say, look, we know you haven't put the Ferrari up for valuation. We've looked around. Our client thinks the Ferrari's worth about $180,000. They'll pretty soon come back.
So an avoidant person will go,
if it's too high, here, look, here's the proof.
Yes. Okay, so you can kind of encourage them to say actually no.
So if you look online or something on Redbook, you can go to the top of the range there and say, look at, and say, we think your car's around this. They'll soon tell you if it's wrong.
Okay, so if you're a person listening, you've got an avoidant X, you want to figure out what your property pool is, whether you've got a lawyer or not.
Yep.
So start writing things down, start doing your research, and then send them a letter saying, hey, I think roughly...
This is my understanding of the assets.
Yeah.
I use that word a lot. And if you've got an avoidant person, you'd say, maybe make a little table, not an Excel spreadsheet unless you have to, because it makes me break out in hives. And of course, if a person's a bit depressed as well, but you just have a list of what the assets are, have a list of what you think the value is, have a list next to it of what the debt is on each of those things, and put in a total and say, look, I think this is what we've got.
Yeah.
What do you if I don't hear from you by 4:00 in 10 days' time, I'll assume this is the property pool we're working on. Now, if you do that and you haven't issued subpoenas and things, you want to know for sure in your heart that you actually know what the position is. So if you've got a sneaky person on the other side, you would never do that.
No.
Because they may have something hidden and they'll go, all right, I agree with that.
Yeah.
When they don't really.
So you've got to make sure that you are 100% sure that there's nothing being hidden. Yeah.
And I always ask my clients about the person's history with money. And often in a marriage, there's someone who keeps track of all the dollars and another one who just got no idea and blows it. If that's the sort of person, the avoidant person, never looked at the bills, doesn't know, then you've probably, our clients have probably got the right idea and they know what's what. On the other hand, if you've got, and here's the test, if you've got someone who never talks about super or who seems to always have their money tucked aside and very carefully doling it out, then I would never try that approach with them. But because that's more controlling behaviour, not an avoidant.
Yes. I guess sometimes maybe just to check if you've got an avoidant who doesn't like being involved in money, they might have 4 or 5 super funds and they've never rolled them together.
It into one. Or you did when you met them.
So make sure that, you've checked all of those things, and you can do that with the SIF form. Yeah. And we talk about that in the course.
And people don't tell you who their super funds with, but they'll always talk about where they used to work.
Oh, that's true. So you can find out.
Yes.
Yeah. Okay, so, and that tip number 5 then, Mum, which we've been talking about the whole way through, is if I don't hear from you, I'll assume you agree. Or if I don't hear from you by this date, I'll assume it's correct. You can't just say that straight away, though. You've got to give a timeline.
So you say, this is what I think it is, my understanding of it is, and if I don't hear to the contrary from you by 4 p.m. next Thursday, or Thursday in 10 days' time, then I'll assume that you've agreed. Or you say, if you don't agree with this, let me know by 4 p.m. on this day. And that means if they let that deadline go, then they've agreed and you're entitled to proceed.
What about in children's matters? So imagine you've got, an avoidant person who doesn't even want to talk about the issue, and there's a disagreement about handover time or something like that. Can you get away? How do you get around that? Is it harder? It
is harder because at all times we're not just lumping money forwards, we've got children with feelings. So if you've got someone who, for instance, won't commit to regular time with the children, there's nothing you can really do about it. I've had ladies in the past, often women, say, if only he'd agreed to a particular time and a particular day, then I'd be happy for them to go, but I can't handle this, off and on. Well, sometimes you have to handle the off and on, and you couldn't say to a person in children's matters, you couldn't say, I'm going to have the kids at the park at 4 p.m. on Saturday afternoon, and, you need to pick them up from there. If they're an avoidant person and they may or may not come, what do you say to the kids? So it's a whole different thing. It's a whole different thing. And no court will order that a person have time with the children if the person doesn't ask for it.
So I guess if you've got an avoidant parent in negotiations, that's where we're going to get to number 7, and we'll talk about that in a minute. What if they're active parenting, but they're just avoidant about discussing certain issues, and you haven't got orders yet? Is it just get to orders as soon as you can?
If you need to. It might be that you can blend something in. So one of the ways of doing it might be just how you structure who drops off and who picks up. So you might say to your ex, look, I know you go to, sewing classes or footy or whatever on a Tuesday afternoon. Would you mind picking the kids up
on your way back?
Way back. Or you say, you know how you go with Joey to basketball? Well, do you think if I drop the other 2 down, could you take them all home for that night? Just try and make it easy for them. But yes, you never want to be in a position where you're there trying to get the kids to go on a thing and the father or mother is refusing to take them. Or where you set the kids up to fail and say, mummy's coming soon. And mummy doesn't. Awful. So, and I guess then with child support and an avoidant parent, that's up to child support.
So what do you mean by that? Support. So does if they're not contributing, they're not paying, they're not helping, you could go to child support. And what does child support do?
Well, you tell child support your reality.
Yeah.
And they will try and check it with that person.
Yeah.
And they do a bit of that. If we don't hear from you, we'll assume that what your ex-wife or ex-husband's saying is true. And then they will assess child support accordingly. And if it ends up that you've got 100% of the time with the children, so be it.
And what if they refuse to pay child support? Sorry to interrupt this episode, but we have a really important announcement that very well might just help you out. Are you feeling confused, lost, scared, and overwhelmed by the family law legal jargon and processes? Join the club. Now it's your chance to empower, educate, and equip yourself with the legal know-how and tools you need to get divorced and finally settle. Introducing the DIY Divorce Blueprint, created lovingly by Mum and me. We've downloaded Mum's brains into 42 video lessons lessons, along with over 100 templates and worksheets that you can use to create and settle your property and children's matters. Follow our guide and steps and templates to get yourself finally settled in divorce. Use it as a guide with your lawyer or without, but hopefully using this DIY divorce blueprint, you can stay out of court and you can get it settled and sorted at a fraction of the price. Click the link in the show notes to find out more, or go to thedivorcecourse.com.au/enroll. See you then. And what if they refuse to pay child support?
Also, you can use child support agency to collect from their employer, or if they're a business, collect straight from their business. If they don't have any other money, they can do a little scoop through around tax time, or they can take it out of their bank accounts and pay it to your
Wow, that's a big deal. So to the listeners that have written in saying, oh my goodness, the father's disappeared, he's stonewalled, or the mother's disappeared and stonewalled, I'm all alone with the kids, you can go to child support, and even if they don't even speak to you, child support will do it all.
They'll find them if they're on Centrelink of any sort, or if they pay taxes. They'll find them in our country.
That's a way around.
Yeah. Okay. A child support's a fight you don't have to have anymore.
Which is great. Isn't that great?
I can tell you my early career, because the Child Support Act came in 89. My early career with chasing maintenance for the children was exhausting, disappointing, hard. You had to prove the actual amount you spent. And the orders those days were terrible, like $25 a week for each child, which I had clients say that wouldn't keep them in tuck shop.
Well, there you go. So that's great news, at least for some people, to help them with that. So then, okay, let's go back to stonewalling, avoidant. They don't respond to anything. It doesn't matter whether it's property or children. Your tip number 6 is when you're making this proposal or asking them a question, is you've got to have your plan for if you don't get a response.
Plan B, that's right. Plan A is that, like a normal person, they respond and you get your information or you get your agreement or whatever it is you're asking for. Plan B is always have a plan for what if they don't. Always put a deadline in a document, but that deadline is also not just this is the deadline after which I'm going to be very disappointed in you. Even if you don't tell them what the or else is, it's going to be your deadline and you know what your next step's going to be, and you can always take a positive step. So it might be that in all of this terrible stonewalling you've decided, you know what, it's just too hard, I need to get some subpoenas, so they don't answer straight to court, you know.
And I think in our episode on ways not to freak out, one of the things we did say was if you have a plan, so before you've even sent the letter going, oh my gosh, I know they're not going to even answer this, God knows even if they're going to read it, but if you have your plan before you even send it going, look, they're probably not going to read this, they're probably not going to respond, but if they don't, I know exactly what I'm going to do next, and I might even have it written out or filled out, ready to go. So at least you feel better in that 10 days of waiting that you set up for yourself, going, oh, what if they don't answer? What's going to happen? You go, no, I'm not worried about that, because if they don't answer, I know what I'm doing next. It's sitting on my desk ready to go.
That's right. And it does make... What happens in a lot of cases is you write it to the person, they don't answer back. Sometimes people don't even give them a deadline. I look forward to hearing from you. Please respond at your earliest convenience.
That's a lot of looking forward.
It is. And you wait 3 weeks, 4 weeks and put, I should do something. Then you think, write to them again. If you don't answer me, I'm going to have to do something. And then that goes another 10, 15 days. And then you go, okay, what can I do? What can I do? Oh, I know, I'll go to court. You've wasted a quarter of a year.
Yeah. And if it's a big issue.
And that's another, another 90 days you've woken up in the morning, put your feet on the floor and gone, oh, sugar. I'm still dealing with this crap. So you want to keep it moving, you want to keep the momentum, and don't let any time lags, because those gaps, those time lags where you're not sure what to do, where you haven't given them a deadline, not sure if they're going to answer, that'll drive you nuts, and it's so unproductive. So there's no reason why you can't think, okay, this is a conveyor belt and I'm going to move it along as quickly quickly as possible to get out the other end.
Whether or not they respond.
It's not an impediment.
It's about claiming your power as well, because sometimes you're being stonewalled because they're doing it as a punishment to you, because you have left maybe, or they're doing it to make you feel bad, or, not all of them are like that. Maybe some of them are just massively depressed.
Yeah.
But some of them, it's a punishment. It's a way to make you feel like you've got no power and you're stuck in this mess forever.
But if it's not a punishment, Laura, let's imagine that being married to this person has been like walking around with a bag of wet cement tied to one ankle.
Yeah.
Like maybe they're like that in everything, and it's so debilitating. And whatever it was that made you leave, you're still dealing with it unless you change the dynamic.
Yes.
You're still at their mercy, still can't. You're organised, you're ready to go, and then there's
the wet bag of cement.
The wet bag of cement. So,
I guess that's right. You've got to change the dynamic, because otherwise what happened in the marriage is going to happen in the divorce.
And it's so painful for a person to go through it all over again. There's a reason you left, and that was to get away from it.
Yeah.
Don't let it mess up your new shiny bright life.
Yeah. And if they've left you and they've hurt you badly and they've done something horrible and they're stonewalling you just to make it even worse,
take your power back.
You take your power back and go, all right, well, you're going to be on my conveyor belt whether you like it or not. And we're on to the magic number 7.
Yes.
For anybody who has a person who is stonewalling them for whatever reason, Mum. And what's that? What's
default orders?
Default orders.
Default orders. Even ex parte default orders. Ex parte means they're not there. They're not even there if they don't turn up.
Okay.
And default orders means orders that you've asked for, you will usually get if they haven't bothered putting in a response.
Okay, so let's just unpack that.
Okay.
So you put on the conveyor belt, you send them letters, they don't respond, you don't respond, you got your plan B, which is putting in to court your application,
and then you
then send them to proposed orders, you serve them, they still don't answer, you get your first court hearing.
And you tell the court that you've served them, file your affidavit and say, look, I've served this guy, but he did have his or her had her eyes shut tight and she had her back to me and arms folded.
What does the judge say?
Fine, that's served. Okay, well, probably then you ask the court for default orders and the judge is going to go, oh, it's a bit soon. But if you keep asking, you don't ask, you don't get. Maybe the court may say, look, it's noted that this person hasn't responded. If they haven't responded by the next time, the court will consider default orders. You serve that document to your ex-partner, and then you do an affidavit saying, I sent these orders, and then the judge will go, well, you know what? They knew that if they didn't come this next occasion, I might consider default orders. They know about it. They know the date. They know the time. Therefore, I'm going to assume they agree or don't have any objection to the default orders, make the orders.
Okay. So you can, without them ever even taking a step into a courtroom, as long as you served them and you've got proof of service, over time you can potentially get orders that are default. Now, does that the same for mediation? Because you know how in the practice, new practice, you have to do mediation first.
Well, if they won't,
what if they don't turn up to mediation?
Right. Well, you can't do it by yourself. So you just say they're not interested. And you know how you said serving them? I remember a matter years ago where the guy disappeared into the Northern Territory. And in that whole case, he left my client with a mortgage and 3 little kids on the house. She couldn't sell the house because it was in his name.
No.
And we got through that. She and I got it through in 3 months so that she could sell the house. I never clapped eyes on him. She never saw him again, never heard from him again, but we did the whole thing. And because we didn't know exactly where he was, we got an order for substituted service. And that was, we said to the judge, we don't know where he is. His brother says he's in the Northern Territory. And the judge said, sure, well, put an ad in the Darwin papers. And that asked him to respond.
Wow, imagine reading the paper, which no one does anymore, and seeing a little ad there going,
oh, Jeffrey, I see you were in the newspaper yesterday.
I guess do they have an alternative to that now in the modern day?
If they're getting any Centrelink payments, the court will order that Centrelink locate them and serve the document on them.
Okay, that's good.
Yeah.
All right. So that is really an empowering thing for anybody out there who is struggling with a person who just will not respond, whether it's punishment, whether it's depression, whether it's any of these horrible reasons why people just stick their head in the sand. So, Mum, let's just go over it again.
Okay.
Don't do a joint divorce.
No.
What happens if they don't turn up to the divorce?
The court usually just lets it through.
Okay.
Yeah.
Well, all right. 2, don't wait a long time for answers.
No.
Because, like Mum said, if you keep waiting and write another letter and another letter...
It'll be a year before you know it.
Yeah.
Wasted.
Number 3, find out, don't ask.
Yeah.
So if they're not helping, just go and look for it, figure it out yourself, do those values, find out your property pool. Number 4, it's okay to guess sometimes.
Yes.
If it's going to help progress the case...
Put a magic E in front of it for estimated.
E for estimate. And
bump it up a little bit
and
to
it
make
might,
sure.
might have upset them enough to respond.
Yep.
Number 5, if you don't hear from you, I'll assume it's correct, or
Yes.
I'll assume you agree.
Yeah. Yes.
That's one great way to get them to
It is
respond.
great. If you disagree, let me know by 4 p.m. That's another way of putting it.
What if they write back and say, don't assume anything?
Tough. They haven't answered.
Oh, okay,
Yeah.
cool. And when writing, number 6 is when writing letters, have your plan B for if you don't get a response.
Yes, absolutely.
And number 7, default orders.
Yes.
Default, the magic word.
Yeah.
I mean, I know we'll probably have some listeners, and we know we've got members that have got high conflict and manipulative controlling, and they're writing letters back and forth like crazy people, and they might be listening to going this, geez, I really wish I had someone who didn't write any letters back.
Yeah,
But
it's just
I guess
as
it's
hard.
just as hard, isn't it?
It's very hard to engage, and you've got to show the judge that you've served them all these times. You have to send open letters. So to get to default orders, you have to carefully build up your case. But, and then ask 1 or 2 times, and then the court should give you those orders. They're more inclined to give those orders because under the legislation, if they make it a default order in the absence of a person, they've got, I think, 28 days to file something and object to the orders. Otherwise, they stand.
Okay. So after 28 days, if they don't respond, then...
It stands, yeah.
Well, at least it gets them to respond.
Because the court has a common interest with you, and that is the speedy and cost-effective resolution of disputes. In other words, they want this off their table.
Yes.
So if you can set up the path for them so they can do it without getting in trouble or being appealed, they'll take it.
And I think that's an important note that... to you, Mum, being in the legal system, a speedy and practical way in the legal system to women, people on the outside, women and men or gender diverse, you're sitting there going, this is taking forever. But in the legal speak, something that happens within 2 weeks is incredibly fast, right?
That's right.
It's something that happens even within 2 months is incredibly fast.
It's got to be. You've got to provide the people with what they call natural justice, and they have to have an opportunity to be heard.
Yeah.
And that you'll understand it if you think of it on the other way. What if you had someone writing letters to you, bombarding you? If you don't let me know by tomorrow afternoon, I'll assume this. You might not answer. You might not get your answer in time. You do want the court to look at that and go, okay, was that reasonable? Was that reasonable? Was that reasonable?
And I think that's an important note. Make sure when you're if you are going to be doing this yourself, make sure it is reasonable.
Yeah. Yep.
Keep in consideration, okay, if your ex does have a mental health condition and they're not coping and maybe they're in a mental institution, don't
write to them on the mental.
Don't write to them and demand that because that's not really going to help anyone.
And don't give them 4 business days or something or 5 days to respond over Christmas, for goodness sake, or Easter,
So try and think practically, okay, how if I was in their shoes, how would I like to? However, in saying that, if they're just being absolute horrible humans and just ignoring the mess that they've left behind you, well then,
You still got to show the court because the court can only make orders that are just and equitable, even in default.
Yeah.
So if you end up in court with default orders, you've got an obligation and the lawyers really have an obligation to tell the whole story. So
when you've got a high conflict but also avoidant, because we do a lot of webinars and there's people that say they've got that
that's
combo.
right, they do, don't they? They say it's
high
both.
conflict and avoidant. I think it's that like where they like to fight about things that aren't important, but they don't want to discuss the things that are important.
Yeah.
What's the strategy for those people?
Well, that's tricky. I think that the only way you could divide the orders that you seek are children and property. I don't think you could cherry pick bits of property out.
Yeah.
So I guess with the children, I don't force it as much.
Yeah.
With the property, I would separate it out and follow that tram lines, that conveyor belt.
Yeah.
I sometimes think of it like fishing. When you get a fish on the line, they run, go back and forwards, left, right, but all the time you're gradually getting them onto shore.
Yeah.
And gradually you'll get a resolution. But with kids, it's a much more sensitive thing where it's a more... Well, you just can't.
But
use a sledgehammer.
If you get into the court system, the court will help it move along.
They will.
Whether or not they want to get involved.
If you have someone with children who absolutely won't get involved in, or who is sporadic, who may be not well, whatever, if you can convince the court of your good intentions, the court may make an order that says that the children spend time with the other parent at all times as agreed between you both.
Okay.
But they don't make orders like that if they think that the person asking for that order is likely to abuse that power.
Okay, and this is all general advice. Mum's just giving examples.
Yeah. I do get cases where if we just can't get engagement, but they're still coming and picking the kids up from time to time, then we just say to the court, look, you know what, rather than try and fence this in, it's in the best interest of the children to let me be able to let him go or not.
Now, the other one is avoidant and manipulative and controlling. And sometimes avoidance is part of the manipulation and part of the control. If it's like that good girl, bad girl guy where, you didn't do what they wanted, so now they're just not going to talk to you for 2 months. Which in some times you'd be like, yay! But in other times you're like, we're not going to be able to get anything sorted.
Well, we fix that little red wagon by giving them those deadlines and saying, if I don't hear from you, well...
And those controlling people really, really want to have a say. If you say, here's my 3 choices of value, or here are my 3 choices of whatever that you need to choose from, or real estate agents, if I don't hear from you by this date, I'll be choosing one.
Yes.
The controlling part of them is going to explode,
and they'll have to
and the avoidant part will disappear for a bit. So
I
guess you just got to balance that out. Can you have an avoidant and amicable divorce?
Yes. Absolutely. Because you can be amicable as a couple, but one of you might really not want to be divorced.
Okay.
And just doesn't want to hear about it, doesn't want to know it happened.
So what's your strategies for that? Kind of the ones we've talked about? It
is kind of having some regard to their hurt feelings and stuff. And we do different types of letters, don't we, for the types of people in our course. So you would tone that letter down very much. But even so, you need to be very clear that if they don't do this, then this is going to happen, and gradually, you're doing everyone a favour. If the marriage is over or the relationship's over, then the avoidant person, but amicable, friendly-wise, will actually feel better, I think, once it's sorted and it's done. Yeah. A lot of people really think they're avoidant because they really worry about the outcome, which... Because they've never gone and seen a lawyer or thought about it, they think it's going to be much worse than it really is.
Well, some people are scared of change. A lot of people are scared of change.
And they all hear these horror stories. And
I guess it's important, though, if you do have an avoidant amicable, to not be writing too much aggressive letters or push it too much to the point where you change it from amicable to a high conflict or something else. So it's a fine balance there. But I guess if you've been married to this person or lived with this person, you'll kind of know where the line is to where not to...
I really worry about when they get to the point it goes, I don't care, whatever you want. That's really hard to make it clear to the court that this person's had options and... Yes.
But if they say to you, I don't care, you can do whatever you want, can you show that to the judge?
Yeah. If it's not without prejudice. Yeah. And then that would be very extra support to the judge for making those default orders.
Okay.
Saying, look, he knew it was, or she knew it was on, they know the date, the time, the court, or the phone number, and they're not here. They might even ring them to give them a chance to say something. They do.
Yeah.
And then, make the orders, get it off the books.
Well, I hope if you are listening, and I know a couple of listeners have written in about it, I hope this has made you feel a little bit better. And the magic word there is if you've got the most like you said, Mum, how to divorce a statue?
Yeah.
Default orders.
Yeah,
If they turn to stone, default orders. And if they disappear into the Northern Territory,
Default orders.
Default orders. Okay, so hang in there. It might be a hard slog.
Yes.
Because you're not fighting against them. You're kind of fighting to prove it to the system.
Yep.
But it's still a hard slog, but you can do it. And, Mum, you've seen it being done before.
I have.
Well, okay. Well, thank you, Mum, for your time, and hopefully that will alleviate some people's worries.
Yeah. Yep. Have a plan. Execute the plan.
Yep. Take care. Thank you, Mum.
No worries.
Bye.
Bye, everyone.
If you found this podcast helpful, we'd love it if you could rate, review, and subscribe. By doing so, you are spreading the word to help someone else just like you. Lynn would like to remind you that this podcast is general advice only, and you should always get legal advice in relation to your particular situation. And remember that the Australian laws may have changed since recording.